Canadian Virtual Employment Law Conference. My name is Marc Belaiche. I'm president of TorontoJobs.ca. We're just going to let people slowly come on. I know there's a couple of sessions or another session still finishing up, so we will start shortly. I'll introduce the panel, and we got lots of great stuff to cover while we're waiting. You can we also do add on an extra 10 minutes after the event, so you can still head into the networking area and the expo area. Officially, the event has 30 minutes left, so you're welcome to still obviously stay with the panel. If you have any questions for the panel, by all means, throw them in the event or in the stage area, and I'll moderate. And we'll get going here. Looks like we're good timing here. So I'm going to introduce the panelists one at a time and just have you introduce yourself a little bit more and talk a little bit about what you do. And great conversation I'm sure we're going to have. So I'm going to go clockwise on my screen. Saba Khan is lawyer at Ryan Edmonds Workplace Counsel. Saba, thanks very much for being here.
Thank you, Marc, for having me.
No problem. Why don't you talk a little bit about what you do, the kind of work that you're involved with?
Sure. So, hey, everyone who's joining us here today. My name is Saba. I'm an associate lawyer working with Ryan Edmonds Workplace Counsel. I advise employees and employers in terms of human rights law and employment law. I always had a passion for human rights law, contract law, and business law when I was coming out of law school. And I felt like employment law was a good way to combine all three of those things. And here I am today.
Terrific. Thanks very much for being on. And Kyle Burgis is senior employment lawyer at Minken Employment Lawyers. Kyle, thanks very much for being on here, and same with you as well. Quick intro.
Thanks for having me, Marc, and good afternoon, everyone. As Marc said, my name is Kyle Burgis. I'm a senior employment lawyer with Minken Employment Lawyers. We're a law firm located in Markham, Ontario. We assist both employers and employees on a wide range of employment law matters and human rights matters across the board and across our province. And I think that's probably a good summary of what we do, and a bit repetitive of what Saba said because we're employment lawyers. So,
for sure, and we got lots of different perspectives on how things are going as well. Aaron Rousseau is partner at Rousseau Mazzuca LLP. Aaron, welcome, and thanks for being here. And same as well, if you can do an introduction of yourself.
Thanks so much, Marc. Much like Kyle and Saba, I also help both employers and employees. So we could probably stop saying that again. I started off at a large firm that I worked at a couple of boutiques, and now I have a practice of my own, and dealing with a mixture of both large companies and also small companies and individuals.
Okay, terrific. Well, thanks very much for being here. And finally, last but not least, Brittany Taylor is partner at Rudner Law. Thanks, Brittany, for being on here, and as well, if you can do an introduction.
Thanks very much, Marc. I'm really excited to be here. I'm going to surprise everybody by saying that our firm also works for both employers and employees. Shocking news. Yes, it's a great practice area. I'm personally, for my practice, I really enjoy doing the preventative side of things. So I really like working with contracts, policies, investigations, discipline, kind of working on the pre-termination side of things. But of course, our firm does a full range of any type of HR related work, and we have a great team that can assist with all of those issues. So thank you so much for having me. I'm looking forward to the conversation.
Thanks, Brittany. Thanks so much. And again, if you're watching and you have any questions, this is a great panel to discuss topics, issues, burning items that maybe you haven't heard so far in the conference that you want to talk about your own situation or something within your organization. Feel free to post it in the chat. So open to anybody here. Who wants to talk about Waxdale? Maybe just what it is, like for the average person who hasn't heard of what it is. You guys are in it every day, but people don't necessarily understand what it is, how it might impact their organizations, and so on. So, who wants to start?
I don't mind jumping in. So Waxdale is a really interesting decision that I think the most important takeaway was that it really reminded us of the difference between the standard for cause at common law versus under the Employment Standards Act, right? So essentially what was going on in Waxdale was we had an employment agreement with a termination clause that included cause termination as well as without cause termination. And the court basically said, listen, because your cause termination provision is not enforceable, we're going to strike out the entire termination provision. And the reason that the cause provision was not enforceable is because it didn't contemplate the fact that an employee who is terminated for cause may still have entitlements under the Employment Standards Act. Okay, so that was kind of the long and short of the decision. And it caused massive panic because everybody was now looking at their employment agreements going, oh my gosh, you know, we don't have a cause provision that contemplates that you might be entitled to notice or severance pay under the Employment Standards Act. And so it caused a lot of panic amongst both employers and employment law counsel for a little bit, I think.
Okay, so
I don't want to monopolize. So
yeah, no, that's great, Brittany. So I'll give other people a chance too. Thanks for opening up. So Kyle, maybe over to you, just to ask you. Let's just pick a random company. They have 10 employees, and they've heard of Waxdale, but they don't really understand what it means. They're maybe thinking about terminating somebody. So what does that mean from a very layman's perspective?
Yeah, I mean, if they have contracts in place, it could mean that this decision could mean that the contracts, if they contain a termination clause, they may or may not be valid, which is nothing new for employment law counsel to have to ask and discuss and analyze. I think a really important factor about a lot of different clauses in an employment agreement, not just termination clauses, but non-solicitation clauses, non-competition clauses. They can be drafted, and when drafted, they can be in accordance with the law at the time. But the law, it does change. It is fluid with decisions that come out. And so if a company is contemplating going through a termination of an employee or a few employees, if there's no contract to analyze, well, then it's a question of how much is the person entitled to and so forth. If there is a contract, it definitely should be looked at, and it should be looked at not just, like I said, not just with respect to the termination clause, but also these other clauses like restrictive covenants that can extend past the end of a employment relationship to see whether or not those can even be relied upon as well. So it is certainly something that companies probably shouldn't just look at a contract, see it says something, and say we're good to go. They really should get things checked out before they decide to move forward, especially if there's been a good amount of time that's passed since that contract was drafted. Okay,
so Saba, this owner of a company doesn't really understand. They have lots of different things going on. Should they be coming to one of you, yourself, or another employment lawyer to redraft their contracts? Like, should they get advice? What should they do? What should someone do?
Yeah, certainly. I think it's important for employers to be turning on their thinking hats and doing their due diligence in terms of contract drafting. So if they've already got contracts in place, then it's a matter of advising them what the potential liability could be if they do end up terminating certain individuals who are currently on those contracts, similar to what Kyle just said. If it's a matter of hiring new individuals, then it's a discussion about how to draft that termination clause in the employment contract to make sure that it's compliant with Waxdale. So what the impact of Waxdale has been that it's effectively rendered a whole slew of termination clauses and therefore employment contracts in the province as unenforceable. There was a time period in between where there was a question mark about Waxdale being, they had sought leave to appeal it to the Supreme Court, and there was a question mark about, is it still vulnerable? Is the Supreme Court going to overturn the Court of Appeal decision? But when the leave for appeal was denied, I think that made things pretty clear and certain in terms of what this could mean for employers. So it is really a matter of employers doing their due diligence. So certainly, if a company came to our firm and they have been to kind of seek advice on what Waxdale means for them, our advice to them is make sure in terms of putting new contracts in place, you have an enforceable termination clause. If they've already got termination clauses in place for existing employees that are no longer, our advice might be, okay, these are looking a little bit vulnerable because of Waxdale, then that's a separate conversation about, okay, what do we do if we want to give these individuals new employment contracts with new termination clauses? There's a separate conversation to be had there because you have to, if I was to put it in a nutshell, you have to buy the employee's acceptance to a change that you're proposing in their employment relationship. So you could technically do that, but you'd have to offer them something more of value than their current existing employment relationship offers them.
Okay, so Aaron, I want to terminate someone. I feel like I'm at risk with Waxdale, so I pay them something to sign something new, and then the next day I terminate them. Is that how it would work, or how it should work? Kind of walk people watching through what should happen.
Yeah, well, that's probably not quite the right way to do it, although it's better than nothing. The big issue with Waxdale is just that terminations have become a lot more expensive than a lot of employers thought they would be. Just because the vast majority of employees are not able to negotiate anywhere near as good as the default rules of reasonable notice. So if you come to me in that situation, I'll probably say, change your mind about terminating the employee, then let's roll out new contracts the next day, then change your mind back and terminate the employee, and let's do it that way so that it's not in bad faith. And you weren't contemplating the termination at the time. But it is a challenge. And what I would do, I would say, let's roll it out for everybody so that you're not targeting this one employee. And maybe then we have some cover on whether we're acting in bad faith in trying to implement that contract with the person we then terminated the next day. But yeah, better than nothing, but it's a challenge.
Gotcha. So Carol has a question here. Does the company have a right to ask employees to re-sign employment contracts? So I think the answer that you just kind of talked about was if there's something in kind or not in kind, but something that they give them back. What is that? Is that money? Is that what is that?
Yeah. So some type of consideration, a raise, certainly if it's bonus time, there are times where employers try to just add something insignificant. Certainly I would recommend to do it at a time when you're doing something like an annual raise or something meaningful that isn't just sort of realistically a sham to try to make the contract stand up. Basically, everybody I say to my clients, if you're doing, if you're rolling something out every year, such as a raise or bonus time, that's the time to implement the new contract. Get them to sign a whole contract at the time that they're signing off on a promotion or on their compensation package for the next year.
Okay, and it sounds like for all of you, you're in general agreement that everybody should be doing it at the same time. All employees should be doing it at the same time, or can you cherry pick which ones to do?
I think that it depends on the circumstance. I mean, I don't see anything wrong with it doing it all at once if it's something that the company is able to actually afford. I mean, there's always that side of it as well. But I think also you can do it individually. If someone is being promoted to a new position, you can certainly have a situation there where it may be possible under the right circumstances. So it doesn't have to be. But I think getting back and Aaron, I think what you were mentioning was, cherry picking for the purpose of doing it because then you're going to terminate the person. That may not be the best path to take. But certainly if you just want to roll it out in stages because there's promotions that are coming and so on and so forth, that may provide an opportunity in lieu of doing a across the board.
Perfect. Great tips. Just to reintroduce everybody here real quick. If you have a question, by the way, you can certainly post it in the event or in the stage area, and I'm happy to moderate. My name is Marc Belaiche. I'm president of TorontoJobs.ca. We have Brittany Taylor, partner at Rudner Law. Saba is lawyer at Edmonds Workplace Counsel. Kyle Burgis is senior employment lawyer at Minken Employment Lawyers, and Aaron Russo is partner at Rousseau Mazzuca LLP. So the elephant in the room is all the stuff that's happening with the pandemic, vaccines, working from home, not working from home, calling people back, workplace safety. What's in a nutshell, because we could probably spend a couple hours talking about this, but kind of what's the quick things that employers should know right now as far as Ministry of Labor, employment standards, common law, whatever it is? Who wants to talk that one?
I'll jump in again. So
yes.
I would say that the advice that I've been giving my clients throughout this entire pandemic is to always approach everything from a position of compassion right? So to try to be reasonable in terms of the directions that you were giving to your staff. And I think that as the pandemic went on, those directives became very clear from the government, right? So for a while, there was a concern about, well, who is essential, who can come into work, who can work from home. And as the time went on, we started to see more direction. So we started to actually get directives that said, if you can work from home, you absolutely should be working from home. You should not be coming into the workplace. So I think that, as time has gone on, like I said, we have gotten more directive, more direction. It's relied less on us having to interpret what we think is reasonable. But I would say the number one tip that I've been trying to give is to try to act with compassion. And I think the other thing is to ask yourself what your needs actually are, not what your wants are, not the way that you've operated your business to date, but what the needs are actually of the business in order to operate properly. And that includes asking questions like, do you actually need employees to be physically in the workplace? Are there other ways that you can still keep your business running without having them face to face, even if that's the way that you've done it for 30, 40 years, right? So I think that's another thing. And then the final thing, I don't want to cover everything, but the final thing I would say is that I've been trying to tell my employer clients that there are lots of supports out there that are available, and to look at them and to consider them. I know a lot of my clients initially were terrified when the wage subsidy was first announced because the criteria was so confusing, and they were really afraid of applying for the benefit, receiving it, and then somehow having it go wrong and all the money getting clawed back at the end of the day, or something awful happening. And that I understand that concern, but that's what employment lawyers are here to help you with. That's what your accountant is there to help you with, to try to navigate those types of situations. But yes, there are benefits available, and if you can, take advantage of them.
Yeah, for sure. Great point. Saba, anything to add?
Yeah, just to add on to what Brittany was saying in terms of approaching things from a lens of compassion, there's also I think human rights considerations have had a huge impact on the discussion around, what you can do and not do as an employer during the pandemic. So in certain instances, individuals have asked, or employers have asked, this individual is refusing to come back to work. They're saying that they have to take care of their kids. What can I do in this type of situation? And in that type of situation, you have to look at the human rights code and see if that individual is protected under certain grounds. And if that is the case, then the employer has what's known as a duty to accommodate the individual up to the point of undue hardship. So much like Brittany was saying, if the individual can, perfectly complete their functions and their duties while being at home and working remotely, and if that's not going to be causing any undue hardship to the business overall, then in that situation, certainly let the individual work from home if they are truly protected under one of the human rights grounds. So I think that's in my practice, I've seen those types of issues arise, and the question becomes: is this individual protected under any of the human rights grounds? And if so, how can we best accommodate them?
Good point. Yeah. Kyle or Aaron, anything to add on that?
I think what Saba was just saying there, I think as well, sort of might pave the way for what's to come in the next few months as well, as we hopefully are going to be coming out of COVID-19. I think that a lot of companies have been able to demonstrate, or a lot of employees have been able to demonstrate to their companies that they have been able to do their job remotely. There may be some industries that have hiccups with that and everything, but there are certainly some jobs that can be done remotely. And I think one of the interesting questions that I think will be facing the employment law community in the next little while is when people can return back to work. Is it going to be a question that they have to return back to work? Especially if there's an accommodation requirement there that perhaps in the past didn't exist, with things like school and so on and so forth, and having to look after kids. I think it's going to open up an interesting door that we're going to have to navigate and figure out in what scenarios it would be appropriate and which it is not, and of course always to that level of undue hardship that Saba was mentioning. So I think that it's opened up for a lot of companies the fact that there are a lot of people who can work remotely and can do their jobs remotely. And to go to Brittany's point there, is it something that you want to do, or is it something that you should do? And approaching things from a compassionate side, I think will be the lens that a lot of companies will be asked to look through on a go-forward basis with this.
That's good to know. That's great. So let me touch on something that Saba said about human rights. I talked to a lot of business owners and employers, and there's a lot of fear of people doing the wrong thing, companies doing the wrong thing, or conversely not doing the right thing, right? Where when it comes to hiring or termination, Black Lives Matter, discrimination, there's so many issues, it seems like, and there's a lot of business owners that are nervous, right? Nervous about terminating a poor performing person and it coming back as a human rights issue. Is there any general advice that you would give to some employers about that? Not to be fearful, things to do that will avoid lawsuits potentially or human rights claims at some point? Aaron, you haven't?
Yeah, so it comes up all the time. And what I tell the clients is I say the key is documentation. So for you to come up with an after the fact justification of why you did what you did that is self-serving and is divorced from any documents is not going to put us in a good spot. But you're not probably going around full of discrimination and bias. Put this stuff in writing. If the people are having problems performing, you may think that you're going to be better at coaching them verbally, but put it in writing. Put this stuff in writing. Do your reviews in writing. Document. And that's going to give you the basis to respond to an allegation that you had some improper motive. And that, to me, that's the number one defense.
Okay, terrific. Heather has a question here. In your opinion, we're going back to Waxdale. In your opinion, why weren't just cause clauses scrutinized to the same degree as without cause clauses by the courts pre-Waxdale? Anyone want to take that one on? Why weren't just...
Sorry, Aaron, go ahead.
No, you go ahead.
Okay. No, you go ahead. No. So, I mean, I think there were some arguments with respect to just cause clauses not being enforceable in the past, and arguments made to say that should invalidate the entire provision. But we just weren't, I think we weren't there yet. We weren't looking at it from the lens of, we want to look at employment agreements as a whole. And I'm not saying that hasn't been a lens that we've used in the past, but certainly we're seeing an emphasis now from the judiciary when they're making their decisions, when they're reviewing employment agreements. Like Kyle was saying, they're looking at the whole thing. They're not just looking at one section. They're not just looking at one discrete clause. And in particular with termination clauses, the courts started to say, look, I don't care if you have a severability provision in your agreement. I'm not reading one sentence of this separate from the rest of the clause that you're talking about. It needs to be read as a whole. It needs to be interpreted as a whole.
Okay, terrific. Paula has a question here. Your opinion on why Ontario is not implementing a comprehensive workplace harassment and violence prevention policy as it has been done federally? Anyone want to take that one on? Your opinion on why Ontario isn't or hasn't implemented a comprehensive workplace harassment?
Yeah. So I'll say a couple of things. One is that there's a few problems. One is that there's different legislative areas that are, in some sense, all trying to deal with the same thing. So workplace safety laws are trying to deal with it. Human rights laws are trying to deal with it. It's also being dealt with indirectly through workplace safety and insurance issues, which is not the same as workplace safety. And it becomes becomes unclear where responsibility for this should lie. Also, I would say the federal changes didn't happen overnight, and they came in some degree, I would suggest, as a learning experience based on Ontario's first effort, which since has been modified in connection with what was then Bill 168, adding workplace violence and harassment, but maybe not giving a thorough treatment to the issue. So I think you will see a further response in Ontario within the next couple of years. I don't think this is the government that has that near and dear to its heart, but it will come.
Right. So let me ask you more of a broader question, and because there's four of you here, what should a company look for when they're looking? They need to get an employment lawyer. Like maybe now's your time to do a mini pitch about why to use you versus someone else. But what are the things that they should be asking employment lawyers? Who wants to take that one on?
I think lawyering style is important. That's definitely important, and I can I've worked with lawyers who take an approach that is, particularly aggressive, and for some clients that works, and some clients actually like that approach. They want to kind of go, full blazing guns at the employer, or vice versa. Not all clients like that approach, though. Some clients like the approach of quick settlements, quick resolutions, not being unnecessarily aggressive, and it doesn't always work to be aggressive. I'm coming from a firm that kind of used to take that approach, and now I'm with a firm that takes a slightly different approach. And so, it does, both things work out, but it kind of depends on what the client ultimately wants. Sometimes taking an aggressive approach can result in an early settlement, but not always. Sometimes it actually backfires and causes the temperature to rise unnecessarily in the other room, such that you won't be reaching a quick settlement. So I think it depends on the kind of style that you'd want from a lawyer, because not everybody has the same style. So I think that's definitely one important consideration.
Okay, good. What's next in employment law? Like over the next 6 months or the rest of 2021, is there a case pending that the companies should know about? Is there any like a Waxdale that's coming? Some kind of case or anything like that? Is there anything on the horizon, Kyle?
I'll jump in. I haven't heard of any cases that are on the horizon, and I'm not entirely sure if it has anything to do with just the number of decisions that are being heard because of the current situation that we're in, and the impact that it has had with the courts. But I mean, I think that one of the main topics that will continue to be of I think a discussion amongst employment lawyers and even just individuals that lends itself into employment law is the idea of the vaccinations, and will it be required at the workplace, and can an employer require it, and those discussions, especially as the ages of people who are able to obtain vaccinations comes down further into the parts of the workforce, and hits different age groups. So I think that that is something that at least I'm keeping a watchful eye on, to see where that conversation is going. If there's anything that's being sort of hints towards it in any way as to how it could go. Certainly, I'm sure that the rest of my panelists will agree with me that there is a lot of articles out there that have been written on this by our fellow members of the bar in employment law. Everyone has a little bit of a different opinion on it, or a couple different opinions on it. And I think it'll be really interesting to see where it actually ends up, and if it actually will ever become a true issue, such as a human rights issue, as a failure to accommodate, perhaps. But in my opinion, that's what I'm mostly focusing on, is what I can maybe see happening in the next 6 months.
Okay. And just for the lay person who's just watching, are cases on? Are they on? They're on Zoom, obviously. I'm not a cat, right? But are the cases going on? Are they backlogged? Like, what can someone expect if they get sued, an employer gets sued, or whatnot? What's happening out right now?
I think there is a significant backlog. I mean, particularly, I know the Human Rights Tribunal has been very, very backlogged at this time. I know it's very, very difficult to get anything scheduled. I know Small Claims Court is the same. There, a lot of jurisdictions are not even scheduling settlement conferences right now, so that's been kind of a roadblock. I think that in my experience, that I've been able to work quite well with counsel to try to avoid going through the litigation process if we can in most of my files. But where it becomes necessary, I think what I've seen is longer discovery timetables, like a longer overall plan for the litigation in terms of what steps are going to be taken, just kind of anticipating that there's going to be those kind of delays.
And is it generally then to the advantage of the employer in this case because of the backlog?
It can be, right? Because if you're talking about a wrongful dismissal, the longer that you take to deal with your claim, the more time there is for the employee to find a new job, potentially mitigate their damages, right? So it can be useful, but it also can be really annoying for an employer, because you've now got this file sitting on your desk that you can't get rid of because you have to wait until you get to that settlement conference, or wait until you can get to mediation at the tribunal. So it's not always a good thing.
Right. Excellent. Bob, as noted here, HRTO was backlogged before the pandemic because of lack of members. Now it's worse.
That's true.
That's
Bob is correct.
Yeah.
That's right. Well, thanks very much to all of you. We're just going to wrap things up here. I want to thank everybody who came to today's event. I hope you enjoyed it. The Canadian Virtual Employment Law Conference. The event was presented by TorontoJobs.ca and powered by eventlogic.ca, logic with a K. Again, my name is Marc Belaiche, president of TorontoJobs.ca. I have been joined by Brittany Taylor, partner at Rudner Law, Saba, lawyer at Ryan Edmonds Workplace Counsel, Kyle Burgis is senior employment lawyer at Minken Employment Lawyers, and Aaron Russo, partner at Rousseau, Mazzuca, LLP. Let us know how you liked the event, what you didn't like. You'll get a survey in the next 24 hours. Let us know what we can do better for next time. We're all ears. I want to thank everybody on the team behind the scenes, Alex, Jesse, Rachel, Ann, Sandra, Sarah, Carla, and Ann. Lots of people involved. TorontoJobs.ca as a sponsor. If you have any staffing needs, email sales@TorontoJobs.ca. Visit the website. We're also looking for 2 lawyers, one in franchise law and one in healthcare law. TorontoEntrepreneurs.ca. If you're an entrepreneur, a business owner, make sure to check out the website. EventLogic.ca. If you'd like to sponsor, exhibit at, or speak at an upcoming event, visit the website. If you'd like to have your organization and services highlighted, we have speaker, sponsor, and exhibitor options available. Please reach out whether to myself or EventLogic.ca on the website. They have a great team to help promote an event or put on any event that you might need. I'm also in the event area. I'm putting in the some links to upcoming events, including the Canadian Virtual Recruiters Panel happening this Monday, March 29th. We're already at the end of March. We have the Canadian Virtual Recruiters Conference happening on Wednesday, April 14th. Best Practices for Recruiting Staff happening on Thursday, April 8th. The Canadian Virtual HR Conference happens on Tuesday, April 20th. I'm just putting the links in the event chat. Feel free to check them out if you're interested. And then the Canadian Virtual Lawyers Conference happens on Wednesday, April 21st as well. So you can register at those areas as well. And just to wrap things up, you can connect with me as well on LinkedIn. And for those of you on the panel, feel free to share your information in the, actually I'm putting them in the chat in the stage area, so you can check them out there. We do have another 10 minutes to go, so you can go into the networking area and the expo area, even though the lights are off. And thanks very much for coming. Thanks again to all of you on the panel. See you at the next event, and stay safe and take care of everybody, and have a great weekend as well.
Thank you.
Thanks, Marc.
Thanks.